everyone, welcome back to Western Legal India LLP. Today we're diving into a landmark case that has a profound impact on the legal landscape of India, Sarla Mudgal versus Union of India. This case is about principles that touch upon the complex interplay between personal laws and religious conversions. So let's get started. Imagine a scenario where a person converts into another religion, not out of genuine belief, but to exploit legal loopholes. This was the core issue that was faced by the Supreme Court of India, where a man had converted to Islam to marry second wife while he already had a first Hindu wife. The petitioners in this case were Hindu women who found themselves in a dire situation. Their husbands, taking advantage of the personal laws which allow polygamy, converted to Islam, not because of the genuine belief, but to exploit a legal loophole. So the question before the Supreme Court was, can a Hindu man married under Hindu law escape the prohibition of bigamy simply by converting to Islam? The judgment of the Honorable Supreme Court can be understood in three heads. The first is, what is the status of Hindu marriage after the conversion of the husband? Second, what will be the status of the second marriage, which was a Muslim nikah after conversion to Islam? And third, can one personal law override the other? So the first issue, whether the conversion of the husband, is as follows. The conversion of the husband does not affect the validity of the earlier Hindu marriage per se. Rather, at the most, Hindu wife will get a right to claim divorce on the ground of conversion under section 13(1) Roman 2 of the Hindu Marriage Act. As in the present case, the Hindu wife has not obtained divorce from her husband, then the marriage will be deemed to be subsisting at the time of and yet to be dissolved. For the second issue, the court said, the second marriage, though contracted under Muslim personal law, wherein limited polygamy is allowed, it was solemnized within the apostate husband, between the apostate husband and the earlier Hindu wife living. Therefore, by virtue of section 5 Roman 1, read with sections 11, 17, 13 and 15 of the Hindu Marriage Act, read with sections 494 and 495 of IPC, marriage by an apostate husband under the Hindu Marriage Act would be in violation of principles of natural justice, that is, justice, equity and good conscience. Moreover, such a marriage would be in violation of Hindu law, which promotes monogamy, and such marriage would be in violation of terms of section 494 IPC. Therefore, an apostate husband has no right under the Hindu Marriage Act to marry again without getting the previous marriage dissolved. As for the last issue, the Supreme Court said, as per the general rule, if there is a conflict between personal laws, neither will prevail. However, in the present case, due to earlier existing marriage, which was solemnized according to Hindu law, the civil rights and obligations were created in favor of the wife who was a Hindu at that time. And therefore, the second marriage of the Muslim nikah would not prevail. In conclusion, this is a perfect case of how legal systems and personal laws intersect and sometimes clash, affecting the lives of ordinary people. It is significant not only for the legal implications, but also for societal impact. This case highlighted the need for legal clarity and consistency in addressing issues related to marriage and bigamy, ensuring justice and equality for all parties involved. Thank you for your time. Thank you for listening. I hope you like this video, which would have shed some light on how Sarla Mudgal versus Union of India shaped the further legal jurisprudence. If you have any questions or need further clarifications, feel free to leave a comment. Don't forget to like, subscribe, and hit the bell icon for more legal insights. See you in the next video.